Domain tools help security analysts turn threat data into threat intelligence. They take indicators from your network, including domains and IP addresses, and connect them with nearly every active domain on the internet. Those connections drive risk assessments, help profile attackers, guide online fraud investigations, and map cyber activity to attacker infrastructure. Fortune 1000 companies, global government agencies, and leading security solutions vendors use the Domain Tools platform as a critical ingredient in their threat investigations and proactive defenses. For more information, visit securityweekly.com/domain tools. Are your existing solutions able to take advantage of real threat intelligence? Common solutions like firewalls weren't designed to handle the massive and growing volume of threat indicators. This challenge often results in significant gaps in your protections, even when you think you have it covered. You need to protect yourself by filtering network traffic against unique threat indicators in a way that allows you to act. Polywall by Bandora Systems is the solution that filters over 10 million indicators right out of the box. Developed in partnership with the Department of Defense, Polywall is affordable for companies of all sizes. Get your free trial today at bandorasystems.com. Rapid7 powers the practice of SecOps. Using shared data, analytics, and automated workflows, SecOps unites IT, DevOps, and security teams to make security an outcome of innovation. Rapid7 combines technology, expertise, and advocacy to drive vulnerability management, application security, incident detection, and log management for more than 7,000 organizations worldwide. Power up your SecOps practice with a free trial at rapid7.com/securityweekly. Hi, everyone. Welcome back to Business Security Weekly. Michael Santarcangelo is somewhere in the world helping people communicate and hopefully doing a good job at that, as he always does. So he is not here this week for the show. However, I would like to welcome back to the program Edna Conway from Cisco Systems. She's the Chief Security Officer for the Global Value Chain and an attorney. Do I say former attorney or attorney? Is that...
I think I'm still always an attorney. I like to say I'm a reformed attorney.
Reformed attorney. Well, Edna, welcome back to Business Security Weekly. It's nice to have you.
My pleasure.
And we're talking about IP, but not the IP like layer 3. We're talking about intellectual property today, which I think it's so important to have this discussion, Edna, in a business context. It was one of those things that I wish I paid attention to more when I went to business school and then had some real world life experiences with intellectual property, and I'm excited to have the discussion today. And I think we want to start off by talking about what is intellectual property, and we use these terms like patents and trademarks and copyright, and how do we, get a handle on what all those things mean, especially to us as business owners.
Yeah, so it's a great area to be thinking about, particularly in the context of security. But by way of background, let's just sort of set the stage, right? What I'll talk about is a general sense. A lot of it will rely on some U.S. law as examples, but keep in mind that there are many nations around the globe who focus on protecting intellectual property. Let's start first with a fundamental misperception, specifically, in all honesty, with patents, but also applicable to copyrights and trademarks, right? There is sometimes a perception that it gives you a right. A patent or a copyright, it's not a right to use, but rather it's actually the right to stop others from making money from an invention or from duplicating in a way that has commercial value what we'll talk about, which is an original work, which is copyrightable, right? So let's just start with patents. I mean, in most nations around the world, there are some fundamental concepts on what you need to have in order to patent a so-called invention. It has to be non-obvious, or is the language that's usually used in most nations. So let's call that in plain English. It has to be new. It has to be novel. If it's granted, by the way, the general average life varies a little bit nation to nation, is 20 years that you have that right in which to preclude others from actually engaging in commercial use and practicing, i.e. making or selling the invention. And I guess there's one thing that's really important to me, which is if you go back years ago to what fundamentally caused us to think about patents, we wanted to encourage invention for the common good of humankind. And so often certain things that you might think are a fantastic invention or discovery are not patentable because they need to be there for all humanity. And a classic example of that is a math equation or a theorem. You can't patent it. We all need to be able to use it. It's a fantastic discovery. So let's move on from patents to copyright. Copyright is generally, it protects the expression, if you will, of an idea in any form. It could, in this day and age, actually be software, right? It could be code. It could be a traditional work of art. It could be a work of authorship. So think words, sounds, visual creations, software, digital embodiment of those kinds of works. It's complicated in the sense that the number of years of protection that you get to preclude someone from using your work in a way that you did not authorize and from which you did not benefit if you choose to do so is probably anywhere from over 100 years to something less. So let's just look at the U.S. as an example. And I'll talk about works that were created after January 1st, 1978, because there was a whole different set of laws. For works created after 78, it's the life of the author plus 70 years, which is a very interesting choice of numbers. The thing that's really interesting is, like patents, there are certain things, right, that you can't have a copyright in. So what might those be? Anonymous works. If you don't identify yourself, if you will, as the creator of this expression of an idea, or if you do it under a pseudonym, which is quite interesting, it is not generally copyrightable. And here's the one that I think all of us who work for anyone, whether we are in a gig economy where we're doing services, or whether we're actually working directly as an employee for an employer, a work made for hire, right, which is basically everything for what we create for our clients and or our employers, is generally not something that you can create for yourself if you've engaged in some kind of agreement with your employer.
And now, copyright is different in that it doesn't require the use in commerce or use in making money. Essentially, is that true?
Well, I think that is true. It has to be the emphasis on copyright is an original work, right? So this is why we see so much debate in this day and age about, is there a section, for example, of music that is so similar that it infringes on the copyright of someone else, or if it was not copyrighted, is it something that can't be copyrighted because it's not original, because it relied on that? So too with patents, right? Prior art.
And there's a ton of, in music especially, which is, I'm actually studying for an upcoming talk if it gets accepted at DerbyCon, and I've seen it in other security talks in different genres of music, rock and roll and rap specifically. There's a lot of sampling and borrowing of music, and a lot of legal cases that have gone pretty much either way. And I think, we see that in security when we borrow an image from somewhere or use some other type of work. So I think it definitely plays in our space today.
I think it does. And I think it's always important for us to remember that at some point, we talked about the societal good, like patents, there's an underlying right to use these unique original works or expressions if the use is for the good of society. So think about, it's called fair use in the US and in many other nations, but think about for political debate, for satire, for education in a school, for other non-commercial uses. So we want to recognize innovation when it's used to make money, but we also want to spread the wealth on innovation in non-commercial environments. And that's really poignant with trademark, right? A trademark is something that's a little bit different. Trademark or a service mark is generally it's a word or a phrase or a symbol or a design or a combination of those. It can also even be things like smells, and sometimes sounds, but this is about identifying a specific set of goods, or a source of goods or services. So when you think about, for example, the classic example is for those of us who are of a certain age, the Good Humor truck, right? It had a specific jingle. That was Good Humor. That actually was, believe it or not, a trademark. And it was related to the Good Humor products of ice cream. And so the point is we don't want to confuse consumers. And it goes to one of the fundamental things we talk about in security, which is counterfeit.
Mm-hmm.
Right? A trademark allows you as an acquirer of a service or an acquirer of a good to say, I know this is sort of the imprimatur of genuineness.
Right. Now, are trademarks different in that in order to maintain your trademark, you have to protect it and you have to keep using it? Are those two things that are associated solely with trademarks?
So patents, you don't really have to use it. You are correct.
Mm-hmm.
That is also true with copyright. The rules around trademark are a little bit complicated and they vary depending on the nation, but you have hit the nail on the head with the general concept is I am saying that this is associated with something I offer in commerce and I don't want to confuse the buyer or user of it. Mm-hmm. If you are no longer offering it for commerce, the question becomes, is it a valid trade or service mark any longer? Because you could have precluded the very purpose of the grant of the mark, right? And you also need to do something to tell the world that it is in fact something that's a mark, whether it's you're officially registered with, in the US, for example, the circle with the R, or whether it's the simple circle with or just without a circle, a TM, which says, hey, I've applied for this. It is a trademark, or there may be some common law rights in it as well.
Right. Yeah, we could do a whole series on trademark alone.
I think we could, but I think what I wanted to spend a little time talking to you about was, and this is a sort of odd thing to say, but I do have a favorite form of intellectual property, and my favorite form of intellectual property is a trade secret, right? Because it's so broad. There's a beauty to the trade secret. You don't file anywhere. You don't register anywhere. Most democratic nations and some non-democratic nations recognize trade secrets. It's confidential business information that gives you some kind of competitive edge. So it can be things that we often don't necessarily equate with an invention. But suppose you have a complicated pricing scheme in my world with the full spectrum of the third parties with whom you operate. Pricing scheme and who you give what discount to based on what they've done in terms of value-added resale, volume of business, et cetera, that could be a trade secret. Examples are very broad on trade secrets as well. It's not as narrow. It could be the research and development information around software algorithms. It could be R&D around hardware. Massworks, for example, are actually copyrightable. You might choose not to copyright them. It could be designs. It could be formulas.
Now, I've used in the past, and I want to run this by you and get your take on it, the recipe for Coca-Cola. We seem to always come down to the recipe for Coca-Cola. Now, what I've been told is that the recipe isn't so much of a secret. What I identified as a secret is I'm like, it's probably how they're able to mass produce and distribute that recipe, not so much the recipe itself. Is that an example of a good example of trade secret?
That's a great debate. And because they've been so good about keeping it a trade secret, I would argue that it's a little bit of both, right? I mean, it's because at the end of the day, a recipe is only down to ingredients. And you are correct. If you get your hands on the recipe, just because you have it, you may not be able to actually duplicate it with the same taste, consistency, texture, and all the things that go into a recipe. And if you do it, you might be able to do it once, but can you do it around the world in a consistent way? Think, for example, McDonald's. I mean, obviously there's variability on raw materials in enterprise products. There's variability on the quality of ingredients. How can you have the same taste in Shenzhen, China, as you have in, St. Petersburg, Florida, right?
Well, I think about it like cigars. It's a little bit of
both, Paul.
I think about it like cigars, too. A lot of cigars, I know the ingredients. I know which plants, which priming, all of the different types, which countries they're grown in. Could I reproduce that? No way. To go from seed to cigar is a proprietary secret to every single cigar company, and that's what differentiates them. So
I think that's a great example. And so let's not forget, remember I said it was my favorite IP, and it's because it's so broad. The process, use your cigar example. I'm not a cigar smoker, but it could be that I only pick the leaves. You might know where they're from, but I only pick them at this level of maturity. It could be that I expose them to this level of drying at this temperature for this period of time. So there's a whole set of variabilities that may not be registerable. And remember, you register because you're getting it right for someone else not to use it. Suppose you want to use it in perpetuity. But here's the kicker with this favorite form of IP, the trade secret. It's only as good as a couple of things. One, it has to provide you with a competitive advantage, and you have to be able to prove that by saying it is unknown to others, right? And most legal systems around the world say, hey, if it was disclosed in an unauthorized fashion, that doesn't mean you gave it up. It just means somebody disclosed it and they shouldn't have, and that violates trade secret. But here's the beauty of the trade secret. Why you really want to have one, that if you want to retain something in perpetuity, is you want to make sure that someone else doesn't have an unfair advantage. So how do you pursue the theft of a trade secret? You say you have unfair competitive advantage because you got something that it took me 50 years to develop and perfect. And now you can do it in exactly the same way without the 50 years of investment, time, energy, resources, et cetera, put in. And so I think that's something that I want to link to our discussion about security, which is what we always talk about.
And that's really interesting. So there is case law around trade secrets. However, it's not something that I can go apply necessarily for a patent, a copyright, or a trademark.
That's correct. And I think the beauty of trade secrets can very quickly disappear to dust if you do not recognize that you have to take steps to keep it secret. And those steps have to be reasonable under the circumstances. Well, you can imagine how broad that is, because this is all case law. There's not a lot of statutory law. There is some on what, an unfair and deceptive practice is. But the reality is the burden is on you. You want to keep it secret? What are you going to do to keep it secret? And that's why we're talking about these sort of lawyer-like things in a discussion about security, right? So at the end of the day, security is the ticket to ensuring our IP is protected.
So if you have identified a trade secret, it's similar to a trademark in that I have to identify and protect it as a trade secret in order to defend it if someone were to steal it?
Close, but not quite, because you don't want to. You can identify it to yourself. You don't want to identify it to the world as a trade secret, right? I mean, you don't want to.
Then it's not a secret anymore.
Trademark, you have to tell the world this is a mark and it's associated with me. Whereas, go back to your cigar, right? The particular process for your cigar, that's your favorite cigar, even though you know all the ingredients, and in this day and age, you might actually want to ascertain that those ingredients were sustainably sourced, and you can get that information. You can't get the process of making it give you the enjoyment as you're, God love you, Paul, sucking on that wonderful cigar.
And it's interesting, though, and I've interviewed hundreds of people in the cigar industry. And you get to that point where they're like, no, I'm not going to tell you the process. They'll give you some hints around it, but like those closely guarded secrets, like no way are they giving those up. Even outside of the show, like they're not giving that stuff up.
They're not giving them up. What the challenge is that people forget is, if it gets disclosed in an unauthorized fashion, let's say it's completely legitimate. It's not unauthorized. Let's say there's a lawsuit and somebody subpoenas some information. The subpoena is handled appropriately. The owner of the trade secret says, you know what, I'm going to fight the subpoena. I really don't want it out there. I don't trust the court clerk. I don't trust the person who's going to, review this, whoever it is, because this is the classic example, in all honesty, where the secret to success and the secret to the problems lie with us, the carbon-based units. It's not in technology. We have to take steps to keep it secret. So lots of people say to me, well, in a defense and theft environment, you spend an awful lot of time talking about not just misuse of IP, my friend, but Edna, you're always harping on the least privileged principle, on the need to know. And the reason why is, in a world where your trade secrets need to be protected, how are you effectively segregating and ascertaining whether people really need to know? Because I can make a pretty darn good argument that if you have information that only a small set of researchers need to know, and it's available because you're using, let's not even say it's a public cloud, it's a on-prem, solely enterprise-based cloud that you monitor and you control, but you've given, the sales team, and you've given the channel organization, and you've given the finance organization access to that, when they don't really need to have that access. Now the question becomes, and this is an interesting debate, can you, without it even getting outside, eviscerate the benefit of your magic trade secret protection, which, by the way, doesn't last for any year. It lasts as long as you're good about ensuring security around it. Therein lies the rub. What are you doing internally? And now what are you doing with that external third-party ecosystem to make sure they only have what they need to have to do what it is that you're asking of them successfully?
And that's one of the most challenging things that I think we face in security is how do we, especially as the business grows, manage who has access to what information? I think that's one of the things that growing pains, that's like my number one growing pain in terms of security.
Yeah, you raised something really interesting. I was talking about this with someone the other day, and I said, I think we've reached a point where in the connected world, what we now need is a set of players who may be from multiple places, multiple enterprises, doing different things, but they all need to sit together and literally, forgive me, I'm an old, crew jock, so they need to be in lockstep with their oars, with their movement in and out of the water. Perfect sync. Well, how do you do that without wanting very viscerally to say, let's share all the information with all of the team members to make sure we're all aligned? That's great. That sounds fantastic, but you may have just eviscerated your trade secret protection. So step back a little bit and say, how can I enable that kind of synchronicity across my third-party ecosystem and even across the third-party environment within my own enterprise, right? Sales talking to legal talking to finance, the folks who are doing IoT, talking to the guys who are doing cloud, talking to the guys who are doing different collaboration capabilities without revealing everything. Is there a way to do that? And it starts to force you to say, if I think about the principle of least privilege, now I start to ask a fundamental question. What do I think they need to know? And you know what? You won't always get it right.
Yeah.
But the beauty is if you start narrow and you find a justification for why it should be broadened, your trade secret protection remains in place because you had a justification for why you broadened it. So that kind of logic and that kind of application of security segregation is a beautiful thing.
Do you find that external threat actors are typically going after trade secrets, or is this more like an insider thing? Like when things have gone wrong and a trade secret has gotten out, like what's usually the cause?
Now that's a loaded question. I think there's ample evidence out there that the so-called malicious insider can frequently, if they're savvy, cause more damage by the revelation and sharing of information without engaging in any sophisticated IT attack.
Sure,
right?
Sure.
That is for sure a glaring example that we have in every industry, in every space. Number one. So, at the end of the day, I always say you've talked with several of my colleagues. I like to say that the real currency of the digital world is actually trust. It's the same currency we've always had, right? Back when you were worried about whether the half erect Cro-Magnon person behind you was going to hit you with the club or the woolly mammoth, it's the same currency. Data is actually the fuel that allows you to build the trust, and techniques like things like enhanced intelligence, distributed ledger technology, we could keep going, machine learning. What they do is allow you to believe in the integrity of the data, which is the fuel, which still gets you the same old thing, which is, do I trust the human? That's a long-winded way of saying it's not just the insider. I think we're going to see, if we do not understand trade secrets on one side, and not really on one side, let's say in the center, and the protective environment of IT security and physical security. Imagine something as simple as this. You're in a plant, and let's make it my world, information communications technology. You're in a plant that's building printed circuit boards or printed circuit board assemblies. How many people need to walk down the line that are building your printed circuit board assembly? If you put a really good EE or somebody who knows ASICs on that line, they're going to figure out a tremendous amount. There's no hack. There's no IT involved.
Right,
they walk down the line. Or better yet, put them in a test environment or put them in the failure analysis lab and let them see what's happening. Heavens to Betsy, a brilliant human mind can ascertain a tremendous amount of information from that. So I think we're getting to the point where if attackers are smart and their motivation is economic, boy, what I'd be doing is I'd be looking for ways in to take the most valuable information, whether that information is your trade secret as an enterprise or the fact that you may have a refrigerated medication in your connected refrigerator and you don't really want anybody to know that you're on that medication because we'll reveal way too much about you. So consumer and enterprise are converging in the connected world.
Now, what about and this question comes up all the time, and I believe it relates to trade secrets, is if an individual works for a company and then either leaves or gets fired from that company, and then they want to go work for a competitor. It's a two-part question, right? How is the individual protected so that they can go pursue a career? And then from the company side, how do you protect your trade secret in that environment and strike a balance between the two?
Really hard. So there's been an ebb and flow. Let's just look even in the United States. To be honest with you, Europe is actually more restrictive on this. But, in the U.S., we look at, non-competition clauses with a very careful level of scrutiny for the exact reason you articulated. There needs to be balance. Imagine, for example, if you're an expert on, I was just talking to somebody this morning and we were debating something and I said, well, ultimately, I think what I may be doing is building a Faraday cage and living inside of it. I mean, that's my solution, right? It's a completely sustainable water supply, food supply, all in a Faraday cage. That's my solution. Do you want to live like that? I don't want to live like that. That's your expertise. Let's say your expertise is sustainable Faraday cage to enable the human who wants to opt out of the digital age, and there are some of them. At the end of the day, you have to be able to use your expertise. What you can't do is actually use that expertise in precisely the same way that the enterprise or the client for whom you were engaged, right, a work for hire, for whom you created something and designed it and deployed it, but it's all theirs, you just got paid for it, has paid you that consummate price. And that price is to say, I own it, now you cannot utilize it. So the ticket is a balancing act, and it depends. If you're an author and you only write on a certain topic, that would be harder to talk about what we could preclude you from doing rather than somebody who is a ghostwriter who has written memoirs, who has written technical books, who has written children's stories, right? They have a vast array of areas where they can earn a living. At the end of the day, here's the preclusion argument. You don't want to stop people who are innovative, who have built up a mass of expertise from engaging in the utilization of that expertise for their own livelihood and, quite frankly, for the good of others. But the flip side, to your point, is that's great. Just don't make that cigar using the process that I just articulated with, where I grow the plants may be known, but how long I make them mature, how long I dry them out, in what temperature, I don't know, if you're a wine person, you can have debates with those who are true connoisseurs about the distinction between the age of the wood, the shape of the barrel. All of these have impact. Those matter. Those things matter. There's no easy answer to this. It's a balancing act. And if you're writing a non-competition clause, particularly in the U.S., in this day and age, it needs to be very narrowly tailored. And they are generally looked on with disfavor for the reasons that I just articulated.
Right. So what can, I guess, summarize, and what can organizations do to first help identify your trade secrets and then protect them moving forward?
So I think know where your IP is and what it is, right? And I would say spend a lot of time focusing on your trade secrets, because you probably know what's patentable and what patents you have and copyrights and trademarks. Your legal team has partnered with you on that. Think about whether you have something that actually creates commercial advantage for you that is not well known. And then think about, where is it documented? How is it duplicated? And what steps can you take at a physical level, at a behavioral level with the humans, as well as at an information access level, to protect it sufficiently that if someone challenged you and said, I actually got that in a legitimate way, and I'm now going to go duplicate it, that you would be able to say, no, you received it in an illegitimate way, not with my authorization. First, you'd have to prove that. The real test is, and here's the reasonable steps under the circumstances that I undertook to actually protect it. If you can answer those questions, you have a better argument. But think about it at the beginning. We often talk about design for security. Design for security should include design for trade secret protection.
Yeah, no, that's great advice. And something we often don't talk about here on the network. So I'm glad we had this conversation. Edna, any closing thoughts beyond that? Or are you going to be at the Black Hat conference coming up? I know a lot of people are planning to attend and planning for that conference.
Yeah, I think Black Hat's going to be great this year. Unfortunately, I will not be in attendance, but I think I'd leave everybody with the thought that security doesn't live alone. Security lives in a world where it's designed to protect both us, the individuals, and we, the enterprises. Think about it in that construct and make security work for you and for your business.
Edna Conway, thank you so much for appearing on Business Security Weekly yet again.
Thank you. My pleasure.
And thank you, everyone, for listening and watching. We'll see you next time.